Last week, Narkis Golan was found dead in her home. Like many battered moms, Narkis fought in U.S. courts to obtain protection and relief, but because of the saturated bias that plagues the minds of judges, lawyers, and nearly everyone involved with courts, she received nothing. But she did what many of us could not. Narkis got her case all the way up to the U.S. Supreme Court after New York District Court Judge E.D.N.Y. Donnelly ordered her son to return to his reportedly abusive father. In a unanimous decision, the U.S. Supreme Court found in favor of Narkis and vacated Judge Donnelly's biased and flawed decision, but they remanded the case back to the same judge for re-adjudication. The Supreme Court sent a message that courts did not have to find ameliorative measures to reunify a child if it would expose that child to psychological or physical harm, and all the Supreme Court justices agreed. But upon remand, Judge Donnelly last August not only ordered the child's return, but this time ensured that Narkis wouldn't be able to afford to defend herself in an Italian court. Judge E.D.N.Y. Donnelly ordered Narkis to pay her abuser $150,000. SCOTUS is not aware of how pervasive sexism has spread like a disease within our court system. It is virtually impossible for mothers reporting domestic abuse or incest to find relief and protection for themselves and their children. Remand is not relief, and the Supreme Court must know why. Who or what is responsible for fraudulently convincing judges and lawyers about the validity of parental alienation and reunification therapy? The AFCC, or Association of Family and Conciliation Courts, founded in 1963 by Meyer Elkin and Jessica Pearson, who, you guessed it, were connected to the CRC, Joan B. Kelly, and the Center for Policy Research, of which Jessica Pearson was director. That's where you can get articles saying weird things like, if you don't have a father in the family, you'll be poor, your child will grow up developmentally stunted, your daughters will suffer underage pregnancy, and your children will become delinquents. In truth, what children really suffer from in family courts is re-victimization and post-separation coercive control that courts embolden perpetrators to continue by 1. Intentionally excluding evidence of abuse from the court record, 2. Unjustifiably granting motions that financially sanction battered mothers, 3. Allowing allegations of parental alienation junk science to survive without proof, not that you can prove it because it's a copycat pseudo-psychological condition that doesn't exist anywhere in scientific findings, 4. Allowing perpetrator fathers the time, custody, and ability to coerce their children into recanting at threat of harm, 5. Allowing third-party professionals without sufficient credentials to the power to investigate, prosecute, and adjudge a criminal legal matter of fundamental constitutional importance. What SCOTUS doesn't know is that their decision in Golan v. Saada in part led to the death of Narkis Golan. Remand is not relief because of lower court judges like E.D.N.Y. Donnelly. Narkis is dead because of you, Judge Donnelly, and neither your pride nor your title will fail to overrule that glaring fact. Narkis' son Bradley will now grow up in the hands of his reportedly abusive father. It's funny how the courts don't decry this as the ultimate parental alienation, isn't it?